Welcome back to the Self-Represented Litigant Society's video series on common legal terms. In this episode, we're going to discuss common legal terms that begin with the letter D. Damages are money claimed by or ordered to be paid to a person as compensation for loss or injury. Damages can take many forms and can be ordered as follows. Aggravated damages. Damages which are requested or dispensed by the court, which are designed to compensate a plaintiff for suffering intangible damages, such as humiliation, distress, as a result of the defendant's actions. Compensatory damages are damages awarded for actual loss in order to place the plaintiff in a position that he or she would have been in had he or she not suffered the wrong complained of. General damages are the most common form of damages, and they're damages for non-monetary losses suffered by a plaintiff. These damages are not capable of exact quantification. Examples of such losses suffered include pain and suffering and disfigurement. Nominal damages, or token damages, are awarded to redress a violation of a legal right that the law deems necessary to protect, even in the absence of actual harm. Non-pecuniary and pecuniary damages are damages that cannot be measured in money, but nevertheless are compensated with money, so general damages. Pecuniary damages are damages that can be measured in money, such as special damages. If you are impecunious, that means that you have little or no money. Punitive damages are awarded to punish a defendant for their purposely harsh, vindictive, or malicious behavior. Special damages, on the other hand, are intended to compensate a plaintiff for actual or quantifiable monetary loss. Such examples are loss of earnings, medical bills, repair costs. A dangerous offender in Canada is a person who is convicted of a serious personal injury offense, as provided in the Criminal Code, and who is, after an assessment, found by a court to be at high risk to reoffend, and whose risk cannot be managed in the community. As such, dangerous offenders are sentenced to a detention in a federal prison for an indefinite period of time. A debtor is a person or company who owes money to another. A declaration is an order of the court that declares the law to require or prohibit certain conduct, or that named persons have specified rights in the declaration. This can also be referred to as a declaratory order. It's good to note that usually small claims courts in Canada cannot make declaratory orders. A defense is a defendant or accused person's reasons why a plaintiff or prosecutor does not have a valid case. On the other hand, a defense counsel is a lawyer who represents a defendant or an accused person in a civil or criminal case. A defendant is a person sued in a civil proceeding or an accused in a criminal proceeding. De novo, or trial de novo, or hearing de novo, is a Latin term for new, a hearing after a decision as if no decision had previously been made. A dependent is a person who relies on another for support, a person whom another has an obligation to support. A deponent is a person making a statement under oath or affirmation, often in an affidavit. A deposition is an affidavit or statement made under oath or affirmation. Typically, a deposition is referred to as out-of-court statements under oath, and they could be used typically in discovery proceedings in Canada. In the United States, a deposition is typically videotaped. I'm going to post a link to some celebrity depositions below in the description box. Typically in discovery or in a deposition outside of court, the only thing that's happening is a cross-examination of a deponent. A discharge is a release from an obligation when a legal duty has ended. In the criminal context, this is also used as an alternative to sentencing in jail, an option for an accused who has been found guilty. The result of a discharge is that the offender has no criminal record of a finding of guilt. An absolute discharge is a conviction that is not entered against the accused, and any information or record relating to an offense cannot be disclosed after 1 year from the date of discharge of the order. A conditional discharge, on the other hand, is a conviction that is not entered against the accused if certain conditions that are imposed are met. Any information or record relating to the offense cannot be disclosed after 3 years from the date of discharge order, as long as all the conditions are met. Disclosure is the making of information and documents known and available to a party in a proceeding. There are disclosure requirements placed on parties by law or court rules. Court records can also be disclosed to the public, subject to statutory provisions, common law rules, or judicial discretion restricting access to the records. In criminal disclosure, take a look at R versus Stinchcombe. It is the leading case on disclosure in criminal cases. This case is a Supreme Court of Canada case that deals with the responsibilities and duties of both the Crown and the defendant or the defendant's lawyer in receiving or requesting disclosure. Discovery, on the other hand, is a form of disclosure, whereas there are compulsory rules or mandatory rules by which parties in civil actions must reveal documents and information relevant to the case and exchange them. An examination for discovery, for example, in Ontario, is a civil process where a deponent or a person who's being deposed is under cross-examination outside of court. A transcript is then produced, and that evidence can now be used inside the trial of that civil proceeding. A dismissal is a judicial officer or a judge's decision to terminate an action, claim, or charges. This is in contrast to a stay or a non-guilty or a not guilty finding in a criminal matter. A stay is quite different than a dismissal, and it's good to know the difference between the two. A disposition is a judicial officer or a judge's decision. Also see judgment. Diversion in criminal law is the removal of a case from its usual process. The police or Crown attorney may divert a case if certain conditions are met. There are various formal and informal pre-charge and post-charge diversion programs. Some of these are also referred to as extrajudicial measures or sanctions. An example of a judicial diversion program in the criminal system is when a charge may be withdrawn or stayed if the accused person admits to guilt and does, say for instance, 40 hours of community service, volunteering in the community. Therefore, if the condition of the volunteer work is met, the charge will ultimately be withdrawn. Usually these types of cases involve lesser type serious offenses, such as summary type offenses. Division of property in family law cases means the division of assets and liabilities between parties after separation or death. For married parties, property is divided by equalizing the net family property of the parties. It's good to note that in most or all provinces in Canada, that division of property can only be an order given by a federally appointed judge. So this may determine which court your matter of division of property is heard in. The Divorce Act is a federal statute that governs divorce in Canada, as well as custody access and support in divorce cases. Again, a federally appointed judge is the only judge in Canada that can make an order under the Divorce Act, and this will and may determine which court your matter is heard in. A docket is a list of cases to be heard in a particular courtroom during that day. This list may be referred to as the case event list. A docket is also a record of time a lawyer spent on a particular matter. If you ask your lawyer how many hours were docketed for your case on a particular day, they will tell you, and they will refer to their docket and tell you that a certain percentage or a certain period of time was spent on your case that day. A domestic contract in family law is a contract between people setting out their obligations towards and expectations of each other. There are a few types of domestic contracts, which are a cohabitation agreement, a marriage contract, a paternity agreement, or a separation agreement. Check out the description box below for a link to a video describing in detail the differences between each of these kinds of contracts. Duress is when someone is being forced to do something through physical threats or psychological or emotional pressure. Duress, when signing a contract, can essentially nullify or void a contract or some of its terms. Thank you for watching this video. I'm Jason with the Self-Represented Litigants Society. Check out our website, irepmyself.com. If you're in need of support for representing yourself in any kind of legal matter,